that whole period, actually, March 2020 through, or I mean, yeah, March 2020 through September 2021. But you have submitted a rental assistance application, and so has your landlord. So they shouldn't be able to evict you, even though you didn't, it sounds like you didn't pay the 25% for September 2020 through September 2021. They cannot evict you while you have a rental assistance application pending. So it sounds like you don't have to worry about the period before October. Now for October 2021, the city of LA is the only place in LA County where the protections for non-payment of rent still arguably continue to exist. So the city of LA, basically, when the eviction, when COVID-19 started, the mayor, declared an emergency period, and the emergency period is still pending. It's still happening. So there are protections for tenants saying that you can't be evicted because you can't pay your rent. Because there was no end date on that ordinance, it is still in place, and it is not what we call preempted by the state law, meaning the state law didn't take over and end all of the protections last month. That is what happened to the county law, because they kept extending the county law over and over, and the state law said anyone that kept being extended, anyone that was extended after August of last year, that's no longer valid. So people outside of the city of LA do not have the specific protections for eviction if they're unable to pay rent. But it sounds like you're in the city of LA, you should still be protected from eviction for non-payment of rent. If you get any court paperwork or anything like that, you still want to make sure to go to stayhousedla.org immediately, so that you can fight any case that they bring. Just because they shouldn't be able to evict you, it doesn't mean they won't file a case. And if they file a case and you don't respond in time, they do automatically win. So you really want to watch out for that.
So
I'm sorry, most of the lawyers, I share it too, I'm sure, is recommend that you send one of those declarations that you're unable to pay. It's not required under the LA law, which Sherry is talking about, but it's a good idea anyway.
Okay, I also have another question. So I cannot be evicted. I live in Encino, in San Fernando Valley, so I cannot be evicted, just to make sure on that.
I'm very careful about saying that, because they could file a case. And like I said, you could still lose automatically. So you have protections, you have defenses that you could raise in a case saying, I have a rental assistance application pending, and I live in the city of LA, and I should be protected for that October rent. But yes, you should have protections.
Right.
Yeah.
My second question is, I live in a duplex. The owner does not live there.
Okay, but remember, we want to keep our questions general.
Right. Well, it's about. I just blocked out. If my rent is under protection, not to just to be increased in a certain percentage every year. I forgot the word.
Rent stabilization.
Right. I want to know if this unit that I live in, which was built 12 years ago.
Wait, what you want to know is if there was a tenant who lived in a duplex,
right?
Does the owner live in the other half?
No.
And when was it built?
12 years ago.
So it sounds like it would not fall under the rent stabilization ordinance because it was built too recently.
Okay. So it is not under rent stabilization. Okay.
Okay.
Great. Thank you.
No problem. Anne Marie?
Hey, yes. I wanted to know what your rights to safety as a tenant are in regards to criminal activity and break-ins in the complex. From what I researched, I see suitable locks on doors are required, but does an outdoor patio on street level still constitute as part of your property that should require some sort of suitable locked security, like a security gate around the complex when break-ins have happened?
Okay, so your landlord does have an obligation to keep the unit secure. Usually that takes the form of, like you said, working locks, working doors, whether they need to gate a patio, right? That's the question.
Right, or
It seems,
the apartment complex, yeah.
yeah, it seems hyper fact specific. Ira, do you have an idea?
No, but there's probably, well, I have an idea. Um, there's, there might be a regulation. I'm sorry, did you say you live in the city of Los Angeles? Where do you live?
Yes, in the city of Los Angeles.
Okay. There might be a city regulation about, is there a swimming pool there?
Yes.
Yeah, I'm almost certain then. There's a city regulation that, well, that the area of the pool has to be gated.
Mm,
And if that's the same area as the patio, then it has to be gated.
gotcha. Okay.
The pool gated off?
It's inside the complex. So there's like a front door that I'm able to lock.
I'm asking, to get to the pool,
Mhm.
you have to go through a gate that's secured in a way?
You have to go through yes, like the front entrance of the building.
Oh, all right. Well, then there, it sounds like they're complying. So, but to get to the patio, you don't? Is that what you're saying?
Right, right. So all the patios on the first floor are accessible to the street, and that's how a lot of break-ins have been happening.
Oh, I don't know the answer to that. You should contact the, what is it? It's not called the housing department
Mhm.
of the city of LA, and they'll probably be able to answer that for you.
The Department of Building and Safety?
Maybe that also.
Okay, great.
Or
Either housing or building and safety. I don't really know.
yeah, so either HCID, right, Ira?
It's not called HCID anymore. It was until like a week or two ago.
Oh,
Yeah. But HCID would probably get you there. Anyway, it's Department of Building and Safety, maybe, or the Department of Housing, or its former name, Department of Housing and Community Investment, HCID.
Got it. Okay. Awesome. Thank you so much.
thank you, Ira. Sam? Or actually, I'm sorry, Sam, before you go, just for everyone who came in later, we are just going to answer questions today instead of doing the regular presentation. Please make sure to keep your questions very general. If you have specific questions, I'm going to repost the information for Elena's office hours. If your question is something where you need to talk about the details of your specific living situation or whatever's going on in your case or whatever it is, you need to not do that in a group setting like this. You would be waiving your attorney-client confidentiality. So make sure to go to Elena's office hours. I just reposted them. Instead of asking a specific question here. And please raise your hand if you have a question, and lower your hand once you've asked it, or if someone else has asked your question. Sam, go ahead. We'll come back to you, Sam. Oh, no,
Hello?
you're there. Okay, hi, go ahead.
I was wondering about that future rent payment. Is it true that, like, if someone applies for November, December, and but January is not open yet, and they put in the application with the state, and they can't evict you for that November and December if you can't pay it? And can they take you to small claims court instead, the landlord?
Where are you located?
City of LA.
Okay, so we just talked about this. So the city of LA does still have protections from eviction. for non-payment of rent. So if you weren't able to pay October, if you can't pay November, as long as the emergency period is still going on, which it still is, there are protections for tenants from eviction, even if you can't pay rent. That's not the case outside of the city of LA.
Oh, okay.
So if your landlord does try to evict you for not being able to pay, you should definitely go to Housing is Key and click on Get Legal Help so that an attorney would be able to file a proper answer and raise all of these defenses.
But is there? I'm
how-
sorry. Yeah, but I heard that they could sue you in small claims court come November 1st.
They can sue you in small claims court for the money that you did not pay during the period that was covered by the state law. So the state law covered March 2020 until September 2021. So whatever money you didn't pay during that time, even if so, they couldn't evict you if you pay under the state law. They couldn't evict you if you paid 25% of the rent for September 2020 through September 2021. So you could never be evicted, but they could file a small claims case against you starting November 1st for any money that you didn't pay. So it's not relevant to October rent. And it's not the case that, moving forward, not accounting for the LA City protections for non-payment that, every month that you don't pay the rent, they can just do a small claims case. That was kind of an exception under the state law that required that the landlords do a small claims case instead of evicting the person based on the rent that they owe. So, but if you do have a rental assistance application that's pending,
Yes,
the law
for
doesn't
future
let
rent.
the small claims case go forward while the rental assistance application is pending.
Oh, okay.
Yeah.
And is there an updated declaration form on the Stay House site?
I don't think that there is. The reason behind that is that the state law did expire last month. But if you are unable to pay, as Ira was saying, it's still a good idea to send a declaration and let your landlord know. You can always cross it out and write in whatever month you weren't able to pay.
There's an updated declaration on the website of, Eviction Defense Network.
Okay.
Oh, okay. Thank you.
Thank you. Xavier?
Yes, hi Sherry. Thank you for your time today. I just wanted to know if you can expound upon what is considered rental harassment or discrimination by a landlord or by a property manager. I think the terms are still kind of vague in some aspects, and from my understanding, landlords are supposed to make people aware of things like housing is key and rental assistance, but a lot of that information hasn't been given out. So just what are some of the clarifications or understandings as far as what is landlord harassment
Okay.
in LA County?
Okay. So landlord harassment, it's not going to constitute harassment that they didn't give you a required notice of some kind, or that they didn't notify you about the Housing is Key website and the rental assistance. That should, I believe, does not constitute harassment if they were threatening you, or like any other kind of, like, I don't know if you want me to just explain the different kinds of examples of harassment, but also specifically about discrimination. I think one thing to remember is discrimination is when you're being treated differently based on your membership in a protected class, right? So I couldn't say I'm being discriminated against because I'm a housing attorney and they don't want to let me rent this apartment. That's not, even though, we use that word discrimination like that, that's not what discrimination is under the law. They could not rent an apartment to me because I'm a housing attorney. They're allowed to. So it has to be based on your membership in a protected class, like race, gender, family status, things like that.
Yeah, the reason why I was asking is because it's my understanding that all landlords and property owners were supposed to make everybody aware of their coronavirus rules or regulations when that came into effect starting in March 2020, and that they had a duty or responsibility to make everyone aware of their rights, the remedies, what they can do. As far as we can't evict you for having pets or
Mhm.
having disabled persons. Things that would typically even
Mhm.
violate the original agreement.
Yeah,
A
yeah.
lot of those things.
So they don't have to do that. They don't have to notify you, for example, that they couldn't evict you for having pets, or that your landlord does not unfortunately have the statutory obligation to tell you about every possible defense, or every reason why they can't evict you. The LA City COVID protections, there was some specific things in there saying, within a few months of the protections being enacted, they had to give you, preemptively give you notice. But I think what you might be thinking of is, for example, under the state law, if they ever tried to evict you for money that came due during the COVID-19 period, so March 2020 through September 2021, the COVID-19 period as defined under the state law, uh, if they ever tried to evict you for that rent, they would have to give you a 15-day notice to quit. And that notice to quit does have to include that notice from the state of California that says, you can send a declaration and you can apply at Housing is Key. And yeah, so if they sent you a notice to quit, then they would have to provide all of that information to you.
Okay, yeah, that kind of helps a little bit because I know that, like in some particular cases, like a landlord, you would ask them, "Hey, what am I supposed to do? Do I send a 15-day letter letting you know the hardship letter?" Some didn't respond or didn't want to respond, so it's like, well, shouldn't they? Isn't that part of their responsibility to let people know like that if I'm supposed to send a hardship letter so that way I can apply for rental assistance and do my part to pay, or just totally ignore me and then
Mm-hmm.
just try to evict.
So if they had sent you a notice to quit that told you you have 15, or maybe even they didn't follow the law at all, and they only gave you 3 days to pay rent or quit. Or let's say they did give you 15 days to pay rent or quit, and it didn't include the required notices letting you know about the rental assistance. It didn't come with a blank, unsigned COVID-19 declaration for you to sign and return. Those would all be defenses in your eviction case.
Okay, thank you.
No problem. Leah?
Hi. So I'm actually want to piggyback from Sam's question. I live in an unincorporated area of Los Angeles County, and I did submit my application. It's still under review, and rent is coming up in November, and I'm fearful of paying just a little bit because I'm still waiting to get my application approved. So what I'm trying to find out is, if I pay 25%,
What are you talking about?
am I protected from getting evicted? And submit another declaration form.
Okay, so your question is, I still have a rental assistance application pending. Should I pay the 25% for September through September to avoid ever, risking an eviction case being filed? Does that sound right?
No, I paid all my rent up to now, but I'm having some
Oh.
financial distress, and November rent is coming. And I'm just wondering, what is the minimum amount I can pay where I'm still protected? Because I'm in Los Angeles County and an
Yeah.
unincorporated area.
When did you file the rental assistance application?
About 12 days ago.
Okay, and you filed it prospectively for November and December.
Yes, but I'm still waiting. And I'm confused by this whole process. So I'm like, with the 25%, I'm like, does that apply to me? Like, do I have to pay a minimum amount?
So no, the 25% does not apply to you. It's not really relevant for you at all.
Okay.
The 25% would have applied if you were talking about rent that came due between September of last year and September of this year. So since you're not in the city of LA, unfortunately, there aren't protections for people in unincorporated LA County who can't pay rent in November. So what I would do is send a letter to your landlord informing them. You can still send a declaration informing them that you can't pay rent, And I'm assuming it's, you know, COVID-19 related. Is that right?
Yes, it's affected my business.
Yeah. Okay. So you could send them a declaration that says I can't pay rent for November, but I have applied for the rental assistance. And, you know, just to give them a heads up, and, you know, hopefully they'll understand and be patient for the rental assistance to come through. But I will say, it sounds like, based on where you're at, there isn't a specific protection for you from eviction. So if you wanted to, you know, fully protect yourself, you would have to pay the full rent.
I have a
But,
question
like,
though.
go ahead, Ira.
I have a question. Is it Leah?
Yes.
Where exactly do you live?
Topanga?
I think that's the city of LA.
No, it's not. It's an unincorporated area. It's in between Pacific Palisades and Malibu and Woodland Hills.
Okay, all right. Just want to make sure.
I just don't want to get evicted by not paying anything or very little. And I'm already having a problem with my landlord right now. We've paid all of our rent. We're just, you know, we applied. We just don't know when this money's going to come through. And
It is going to take longer than the end of this month. The money is not going to come through before the end of this month.
I just don't want to be at risk of being evicted because we didn't pay November rent or paid a small amount. I just don't know how cooperative my landlord's going to be.
I think that the most you can do is notify your landlord that you've applied for the rental assistance for November, and, you know, give them the heads up about it. I will say, I don't think that other than paying November rent in full, there's any way to like fully protect yourself from the risk of eviction. But if you do get a notice to quit, if you do get court paperwork, you should go on to Stay Housed LA and click get legal help. It's worth remembering that, you know, if you're unable to pay and you're unable to move, that doesn't mean that, you know,
your September rent, and they don't cash that check. They just cash your rent check, and then they give you an eviction notice, 3 day to quit based on subletting, which I didn't do, which, you know, with Ira's help.
Don't get too much into the specifics.
Oh, okay. I'm trying to be really general.
Okay, so your question is, they didn't accept that 25%. If a landlord doesn't accept that 25% and tries to evict, you know, based on some other made-up reason, you know, what protections exist for you? Does that sound right?
Yeah.
Okay, so whenever you make any kind of payment, you know, you don't want to pay with cash. You don't want to pay with, this is a more general response, but whenever you pay your landlord, you don't want to pay with cash. That's the worst way.
Well, I did video record the whole process of putting in.
Perfect. I'm just gonna talk through it just for the, you know, everybody. But you don't want to pay with cash. You want to avoid check. A check is a promise to pay. If your check bounces, which I've seen many times, it counts as not paying your rent. So you want to pay with a money order or a cashier's check, and you want to keep as much evidence as possible that you've sent it. You want to take a picture, you want to take a video, you want to take a picture of the mailing, you know, whatever it is. So, and it's exactly for cases like this where the landlord refuses to cash a check, or, you know, accept a money order or whatever it is, so that you can keep evidence that you attempted to pay it. If they try to evict you, or if they try to evict, you know, this tenant, for not paying that 25%, if they try to evict you for the rent that came due between some, you know, during the COVID-19 period, it would be a defense that you attempted to pay it. It is a separate question. They can, if they're separately evicting you for, you know, lease violation by subleasing, that's a totally separate case. They can do that. They can file a notice to quit. They can serve a notice to quit and file a case based on that. But based on what you're saying, it doesn't sound like that's factually true. So I would absolutely recommend going to Stay Housed LA, clicking on Get Legal Help, and you know, try to fight that eviction if they've just made up a reason for it.
Right.
It sounds like it's,
I talked to them, and they said that I should call the city. So I'm confused because I think it ties into. Yes, I did have a guest for a few days. Is there a city of LA per se? I know someone called in about county, but is there a standard day like limit to house guests? And I have friends come stay with me. I stay with them. It's like, what, like how, I've been here 28 years, so I don't really have a regular lease. So they're just making stuff up, I think. I
Yeah.
mean, now I'm being specific, sorry.
No, it's okay. I would still, I think my recommendation is the same. Make sure that when you get court paperwork, you immediately get in touch with a lawyer and try to fight that if it seems to be baseless. A couple of days does sound like something you can't evict someone for. That doesn't sound like it would reasonably be a sublease. But as me and Ira did not know specifically if there's like a number of days.
You know, I did. Would you tell me your first name?
Charlotte.
Yeah, I did work with Charlotte, right?
Yes.
And now I'm starting to remember that I did think that there was some law, maybe it was in your lease, but you don't have a lease, that says that guests can stay up to 13 days, and then it's not you can't evict them for it.
Yep.
So now I'll look through I must have sent you an email about that, right?
Yes, you
I'll
did.
look
But I
for
didn't,
that, and if I can find the authority, I'll post it here, all right? Like,
yes.
in other words, I can find some law that says up to 13 days, I'll let everybody know.
Right, but they also, okay, in general, it's under the umbrella of harassment. If landlords are here all day walking around, doing nothing, or are they allowed to just hang out all the time when it's a 6-unit apartment building?
Yes.
And pretend like they're doing work or whatever they're doing?
They're not in your unit, are they?
Not inside, but outside and looking in our windows, all of us.
Oh, yeah.
It might be a different story if they were peering into your windows, but
They do. We have
they
video.
are allowed to be there. Yes.
They're allowed to be there, but
Yeah.
okay. All right. They
Okay.
peer in our windows.
But they can't peer into your windows. It's a violation of your right to privacy.
Right. Well, they do that to all of us. So that's probably,
Record everything.
I know I'm all over the place, but it all comes down to just constant, always something happening. And it's hard to define what harassment, what it really is under
That's
the
why I was
law.
asking, like, what exactly is harassment?
But they do specifically look in our windows.
Well, being around there all the time is not harassment. It's not illegal. But looking in your windows a lot, or maybe even once, is a invasion of your privacy. So that, I don't know if it's harassment, it doesn't matter. It's a violation. Well, it does matter because there's an anti-harassment law
Right.
in Los Angeles. So it might be a violation of the anti-harassment law.
Mm-hmm.
Right.
That's why I was like, what exactly is
Okay,
harassment?
I will research that more deeply because we have
They should know
footage
that, the
of them
lawyers.
doing that.
All right, you might have grounds to sue them, or at least make a demand that they stop, and if you want me to make the demand, you can get in touch with them.
Right.
Okay.
Okay, thank you guys so much.
Okay.
No problem. Luis?
Hi, good afternoon. I have a question. I live in Los Angeles, no rent control building. I would try to put it as not as much specific because if I know you keep repeating that to everyone. The old owners sold the building. The new people who acquire the building, they want everyone out.
Do you literally have to tell people to record everything?
What they're
nowadays?
trying to do is what they call, I guess, a buyback. They were trying to persuade us to by offering something economically, and they want to the building empty by the end of the year.
Okay. So how do you know that the building is not rent controlled?
Because we get the rate. I know for the fact because every year we get raised and it's not under of the amount. Plus, we do not have a utilities are not included, and we don't pay anything of those little fees that sometimes you pay.
How many units are in the building?
As far as I know, there are 44 units.
Okay, and do you have an idea how long ago it was built?
I think it was around, I think it was in the 1980, something like that, 1980, 1970, something like that. I'm not 100% sure, but I know the previous property management has said that this building wasn't rent control.
Okay, I will say, just because a previous owner said it, it doesn't mean that it's necessarily true. It could still be rent controlled. A lot of owners still do rent increases even when they're not allowed under LARSO. So, that's not for sure. When the property is sold, that doesn't change your rights. But just because there's a new owner, it doesn't mean you have to leave.
Yep.
But if the property isn't rent controlled, well, it sounds like it would at least be subject to the Tenant Protection Act, because it's an apartment building that's more than 15 years old. So I think you would at least be, the people in the building would be protected by the Tenant Protection Act, which makes it so that the owner needs some reason to evict everybody. So it needs to be something like not paying rent or nuisance, or they're turning everything into condos. But no matter what the reason is, I would definitely say this is a great, this is exactly the kind of circumstance where you want to get connected with a community-based organization. You don't want to, leave the unit. You don't want to just leave because they're telling you to leave without considering staying, without considering helping to organize your building. So I don't know, Vicente, if you feel comfortable sharing, if you want to share your contact info, that might be a good idea. It sounds like it's just a large building where a new owner is trying to evict everybody, and they're at least protected by the Tenant Protection Act.
Yeah, I'll add my number just really quickly, and if folks want to get involved with any of the organizers, I can help pass it through with Sergio and Hassan. But I'll put my info in the chat.
Okay. Yeah, basically basically as soon as, because I think the new owner just took position on the building less than 4 months ago, so I cannot, so not trying to be so specific, and just one day we had somebody knocking our doors.
You don't need to tell me the details. I understand it. There's a new owner and they're telling everybody to get out, right? And just because there's a new owner, it doesn't mean that your rights change. It sounds like they need a specific reason to evict the tenants, and they're trying to get around that by offering you guys money. So before you consider taking the money, before you consider leaving, know that you don't have to leave. You can fight it. If they try to evict you, you can go to stayhousedla.org, click on get legal help, and if you qualify, be represented in your case. And you really should get in contact with someone at ACE so that they can help with organizing your building, because it sounds like there's 40 families or whatever that are going through the same thing.
Yes, that's what we were being trying to do. We're trying to start talking among ourselves and trying to figure out, because there is people with disability, there is seniors.
I understand, Luis. I just don't want to get too much more into the detail. I think we've talked about the detail a little bit, and I don't want to keep going into detail about it. But Vicente posted his number if you want to write that down. I think it's good to talk amongst yourself, but getting involved with a community-based organization that does this all the time is really the best bet. So it's good to get talking with an organizer.
Okay, so I will go into the chat and look for Vicente information.
Okay, perfect.
Thank you.
No problem. Rebecca Romero?
Hello?
He's the guy running this program, Vicente.
Hello?
Hi, we can hear you.
Oh, okay. I have two questions to ask you. My friend wants to know if City of Commerce is in LA.
I can check right now. Unless Ira already knows the answer.
No, it's not in the, it's in the county of LA. It's not in the city of LA.
Okay. And then my second question is, she had checked at the city to see if the landlord had pulled a permit for substantial remodeling, and he hasn't. And he wants her to move out end of this month.
She said her friend.
Okay, so a few things. A landlord can't just orally tell you that you have to leave. They have to serve you with a notice to quit. And if it sounds like they don't have a valid reason, if what they're saying is the reason, it's kind of just a pretense or something, that, I mean, in general, even if it's not a pretense, I would tell you to fight it if you want to stay. Honestly, even if you don't want to stay, because fighting the eviction case with an attorney will help you get a better outcome for yourself, like more time to move or whatever it is. So really, I think this is a situation. I mean, if you do get a notice to quit, if they do get a notice to quit, and definitely if they do get court paperwork, you want to go to StayHouse.LA and click on Get Legal Help.
Oh, okay.
Yeah, the general point is you don't have to leave just because the landlord says you have to leave.
Oh, okay. Okay, even if I'm even if she's in an uncorporate area?
That doesn't matter. So no matter where you are in the entire state of California, whether you're protected by rent control, whether you're not, whatever kind of housing it is, if you're a tenant in the state of California, your landlord can't just tell you you have to get out and you have to get out, right? They can't change the locks on you. That's illegal. They have to go through the court process, and there's always an opportunity. That is an opportunity to fight, especially if you think that their stated reason for wanting to evict you is fake.
Oh, okay, because she's been at her place for 11 years.
Okay, I wouldn't talk about the details, but do you have another question?
No, that's it. Thank you so much.
Okay, no problem.
Bye.
Bye. Maybe Nicholas?
Hello. Two-part question. I'll keep it concise. I paid my 25% of rent owed from September 2020 to September 2021. And on the check, I stated that this was for September 25% to September 2021. I got a certified letter from my landlord saying they're allocating those funds into a specific month. I'm just confirming that it actually doesn't matter how they say they're allocating those funds.
Doesn't matter.
Okay, great. Thank you.
Yes, there is a protection. There are protections in the state law that say that the landlord can't do that, right? If you try to pay that 25% and they're like, actually, we're putting that towards March 2020 and April 2020, and you didn't actually give us 25%, that doesn't count. They can't do that.
Okay, cool.
Just make sure you keep your proof of payment.
Yep, I have that. I took a video of the check going in the letter, going in the box, the whole thing that y'all have done. Second question is, I paid the 25% of September to September, and last clinic I was at, the consensus was that all of owed rent would need to be given to the landlords by November 1st. Are there any, is there new information on that? I understand it's probably based on state, county, city protections. Can you speak to that a little bit?
Are you in the city of LA?
I'm in Koreatown. I'm in the city of LA.
Okay, and have you done a rental assistance application?
No, because I have a job and I can technically pay it. I'm just trying to save up enough to be able to pay it. I just need to know when I absolutely need to pay it.
Okay, I'm sorry, but you did not have any COVID-19 related.
Oh, yes, I did. And I sent the letters and I deferred rent using the county and the city documentation. So all of that was done properly.
I would still go to Housing is Key and apply for the rental assistance, because just because you have a job now, it doesn't mean that you didn't have COVID-19 related financial distress back, when for whatever period of time you had the financial distress and couldn't pay the rent. You could still apply for the rental assistance for that time. And if a rental assistance application is pending, that will stop them from being able to file a small claims case, or sorry, being able to win a small claims case. They can still file it on November 1st. The city also does have some additional protections for when you have to start paying back rent, but there is a little bit of confusion as far as how the state law interacts with those protections. But I would still, fight it and argue that the city protections make it so that you don't have to pay back all of that rent on November 1st. The city protections said that you have until 12 months after the emergency period ends.
Right. Okay. Thank you. So I'm just wondering, if I don't pay everything back by November 1st, then I'm losing the protections of the county or the state. Okay. And does the city protection supersede that in that case, or?
So that's the question. There's this complicated preemption structure about this, how the city and state protections interact. I would still make the argument that the city protections do apply. They're not preempted by the state law, and that they give you 12 months after the emergency period ends to pay back the money.
Okay, thank you for clarifying. So, got it. And so that state of emergency has actually not been lifted
It's not
yet,
over yet.
Correct?
No.
Okay, cool. So if I do get some formal eviction notice or notice to quit based on rent owed, then I can use that as defense. Okay, thank you.
Yes. Okay. No problem. And use it as a defense, as in, it's something you want to make sure you raise in an answer. I think you already know this.
Exactly.
Specifying for everyone else. It doesn't mean that they can't file a case.
Right.
Great. Okay. There's a phone number ending in 8753.
Can you hear me?
Yes, go ahead.
Oh, great. Thank you so much. I have a question. If you get a no-fault notice, should you still apply for the state rent relief?
I just want to make sure I'm understanding the question correctly, but my answer is probably going to be yes. Just because, so you're receiving a no-fault notice instead of a 15-day notice to pay rent or quit. Even if your landlord doesn't try to evict you based on the rent that's owed during the COVID-19 period, you should apply for the rental assistance. That's money that you owe your landlord, and getting that money from the state will make it so that you are no longer obligated to pay that money to your landlord. It'll make it so that they can't evict based on that money, and that they can't file a case in small claims court. So if you have had COVID-19 financial distress and you weren't able to pay the rent, apply for the rental assistance. It doesn't matter that they haven't given you a notice to pay rent or quit.
Okay.
Yeah.
Thank you.
No problem. Okay, I think Lorena, you're up, and I know you posted your question up here, so let me go back and find it.
Excuse me, I have one more related question to that, if you don't mind, Sherry.
No, go
ahead. Does that need to be done by November 1st?
I would do it by November 1st to avoid them filing a small claims case before you've applied. I would do it now, I would do it as soon as possible.
Okay. And that, but you said before that doesn't prevent it.
Prevent it from being filed.
Right.
Yeah. So there's when you go into a courthouse, I could file a case against, somebody, I don't own any property. I could file a case against someone random pretending to be a landlord. Nobody's going to check it, right? When you file the case. So there's nothing stopping a case from being filed. But I don't want there to be a situation where they've filed a small claims case against you and you don't have a rental assistance application pending. Does that make sense?
Oh, yeah, I get it. Okay. I get it. Okay, cool. Thank you.
No problem. Okay, Lorena. Give you a notice to vacate. A notice to vacate is something that the sheriff gives you, and it usually gives you about 5 days to leave the property, but that's after the landlord has gone through the whole court process. But in general, it sounds like this is a home that's not protected by any kind of rent stabilization or anything like that, if it's just month to month, they should give a 30-day notice to terminate that kind of tenancy. They can do that even if the rental assistance application is pending, because if it's not protected by any kind of rent stabilization or anything, they can evict just by terminating a month-to-month tenancy. I hope that answered your question. Okay. Katie Kim?
Hi, can you hear me?
Yes, I can
Hello?
hear you.
Okay, thank you so much for doing all this. And I have just one question. I mean, two questions. Luckily, I'm so grateful that I am approved. My application has been approved and funded, just pending payment right now. And they've been charging me all that month-to-month fee. Is it? I mean,
okay, so just remember to try to keep the question general. Is your question about late fees?
Month-to-month fee.
What is a month-to-month fee?
Okay, my lease ended, and since I lost everything, I sent them all that financial distress and all that, and I was ready to move out. I didn't want to accumulate, and I don't like having that, so that's why I didn't renew the lease, and it automatically went on month to month, but we never signed on anything. And they can charge month-to-month fee. I was in LA City, ERAP, that they told me that they cannot charge late fees and month-to-month fee. I don't know with this program, because my application got transferred to this Housing is the Key, the state program. So I want to know the regulation before I negotiate with them to move out, because I still have some remaining balance, quite a bit. Yeah.
Okay, so your question is, can they charge a month-to-month fee?
Yes.
And you mean during the COVID-19 period? I
Yes.
don't know of any specific protections that stop them from doing that. Ira, do you know?
Uh-huh.
Do you mean, maybe that we got an answer to what's a month-to-month fee? You mean month-to-month rent?
It sounds like it's like an additional fee because she doesn't have a lease. And now that it's a month-to-month tenancy, there's like some additional fee. Does that sound right, Katie?
Yes, the 10% of whatever rent it was stated on the very last lease contract between, yeah.
Okay, so that was in the old lease.
Yes, a 10% every month that they've been adding.
Yeah, I've seen that before, just
Yeah.
today. Do you, so this is not City of LA?
I am in City of LA.
It's not rent control, or is it?
It's not rent control, it's fairly new building.
How much is the fee?
$300 every month.
How much was your rent before they started the fee?
It was $3,010.
I was thinking, Cherry, of there's a law called the anti-gouging law. They can't charge more than, they can't raise your rent more than 10%, but that's just under 10%.
10% during the state of emergency, right?
During the state of emergency. And
just, it's a, they put as a separate fee.
Well,
that's very tricky. Yes, that's very tricky. Yeah.
Is there, Cherry, can you think of any other?
No, if it's not rent controlled and it's not price gouging and it's in the previous lease, I've seen provisions like this too, and I think they are allowed.
Tenant Protection Act?
Sorry?
Tenant Protection Act?
Tenant Protection Act.
I think that it prohibits that. I think that prohibits the increase, the 10% increase in rent. They can put out whatever they want.
Yeah. I don't know that it prohibits it as like an additional penalty after a lease was complete. It was, finished and then wasn't renewed.
I don't know.
That's
either.
that's the point that I didn't agree on them. We didn't have any contract or agreement on. Just I knew that I was only into LA City ERAP application, and I know I am protected even without paying 25%. That's why maybe they've been charging. I mean, it could be.
Let me interrupt. How long have you lived there? How long have you lived there?
4 years and 4 months.
How old is the property? Do you know?
About 6 years, I believe.
66.
No, 6. Single digit 6. It's fairly new. It's in Playa Vista. It used to be Los
No
Angeles.
Tenant Protection Act.
Right.
No, it definitely enacted in this city, in this apartment that I know of. Because I consulted with the prepaid legal also. That is, I'm under protection. That, now I have to pay remaining balance. They don't seem to waive the fee.
Yeah. So Katie, I don't want you to go more into the details. We talked a lot about the specific details of your case. We want to avoid doing that here. So it sounds like Ira and I can't think of a reason why they would be prohibited from doing that.
Yeah, it sounds like they can do it. Sounds like you've got to pay.
Okay, so if they insisting I have to pay. Other question, I think you guys have been talking about November 1st. I came in 25 minutes late. Civil Code 1951.2. I think that's what you guys been talking about. Like before November 1st, we gotta, submit the application, get the protection.
What's your
I don't know what I couldn't understand about this civil code, and for my situation, what I need to know to protect myself from this situation.
Okay. So I'm going to answer this question generally.
Yes.
Civil Code 1951.2 has to do with abandonment of property. So I don't think that's what you're talking about. I think you're talking about the state COVID-19 Tenant Relief Act. So November 1st is when a landlord, but we just talked about, you're in the city of LA, right?
Yes.
Okay. So under the state law, a landlord could file a small claims case starting November 1st for any money that you didn't pay that came due before, that came due during the COVID-19 period. But you could argue that there are additional protections in the city of LA that make it so that you have 12 months after the emergency period ends to pay back that money, actually.
Okay, I see. That's what it was. So I better be settled with them before November 1st then. Okay, thank you. That'll be all.
Okay. Even if they file a case on November 1st and you're unable to settle it at that time, you can at least argue that the city of LA makes it so that you actually have 12 months after the emergency period ends. So it's not actually due on November 1st.
You should win that argument. That's what the law says. There's no law that says it that overrides it, and you should win the argument. Even though they can sue in November, it doesn't mean they can win.
Okay, so we are still in that emergency period.
Oh, definitely, yes.
Okay, thank you so much.
Okay.
No problem. Lion, or I think you said your name was Laura.
Hi. Okay, so hi. So I have a friend that received a 60-day notice to quit the premises. The previous owner passed away, so about 5 or 6 months ago, they sold the building, it's a new owner. And so pretty much I just have a question. I don't know if I have any way of staying here longer, or do I have to get out within the 60 days?
What kind of property is it? Is it a single family home?
I'm sorry, it's a apartment of 4 units, single story.
4 units. How old is it?
It was built in 1959.
Okay, so it sounds like, so Burbank is not in the city of LA. It's its own city, but it sounds like you should be protected by the Tenant Protection Act. If it's 4 units and it's pretty old, it sounds like you should be protected by the Tenant Protection Act, which means they need a reason to evict you. They need an at-fault reason, which is like non-payment of rent or illegal activity or something, or a no-fault reason. What was the reason given in the 60-day notice to quit?
They put substantial remodel pursuant to California Civil Code section 1946.2b. And then they're also offering, I'm sorry, they're offering to for us not to pay the relocation assistance, to not pay the last month of tenancy, which is next month.
Okay, so okay, this is a very specific, there's a specific issue here. So basically this is a no-fault eviction that technically is allowed under the Tenant Protection Act. 1946.2b is where they list the no-fault reasons, meaning, you know, the tenant didn't do anything wrong. So that's substantial remodel is one of those kinds of reasons. They would be able to evict you under the Tenant Protection Act for that reason. And all they have to do for relocation is they can just waive the last month of rent. The LA County did have protections, or does have protections, saying that you can't do any kind of no-fault eviction right now. Like, you can't evict someone for substantial remodel. So LA County was saying that. The LA County Board of Supervisors thinks that those no-fault protections still exist, even though their non-payment protections are obviously preempted by the state law. So there's no non-payment protection in this county of LA. They think that the no-fault protections should still exist, except the state law does say anything that was extended after August of last year, that it's not valid anymore. So I have had judges refuse to get rid of a case based on the county protections that say that you can't have no-fault evictions. So I think, you know, if they are trying to evict you, I would still recommend, you know, going to Stay Housed LA, clicking on Get Legal Help, and getting connected with an attorney and trying to fight the eviction. You know, who knows, they might not even be planning to substantially remodel. They may not need you to evict to do, they may not need you to vacate to do that. And they may be able to argue that under the county ordinance, they shouldn't be able to move forward with this kind of eviction right now. I just wanted to warn you that that last argument isn't necessarily a slam dunk, because many judges think that that county ordinance is fully, you know, preempted. It doesn't, the state law kind of got rid of it.
Okay. So so if, let's say I do decide to do that, and should I pay the last month, still send the payment for November, or don't pay it and still stay here, or?
So if you're planning to stay, to fully protect yourself, you probably do want to attempt to pay that last month of rent and keep proof that you attempted to pay it. But if they've waived it, you know, or if they're not accepting it, you know, you aren't going to be able to pay it if they don't accept it. So you could still stay, you could still wait for them to file a court case and, you know, get legal help so that you can fight the court case.
And let's say they do, it does go to court, does that affect me in any way? Does it affect in any way?
It will affect you. You know, you'll have a court case. It'll be stressful. But, you know, if you have legal representation, the only way it would show up on your record or on your credit, which I think is what you're asking, right? Like, is if you went to trial and lost. So if you went to go to trial and win, the case will stay sealed. If you enter some kind of agreement with the landlord, your lawyer should make sure that the case stays sealed. so that it doesn't show up on your record or on your credit.
Okay, I was told, because I've been calling different places, and I was told to try to see if I could negotiate something to see if we could stay at least another 2 months to give us time, because I've been looking around Burbank, or just, it's pretty high up there. So, so it's kind of hard. And to send that letter, but to send it till the end of November though. To kind of, it's a letter like saying like no fault eviction to the landlord or to the attorney.
I'm sorry, I'm confused. So there's a letter that says you can't do no fault evictions right now, and your question is, should I send that at the end of November?
I was told to send that letter, to send it like towards the end of November. That way they don't, they don't start planning something, and it gives me time. So if in case they do file something like in court.
Okay, yeah, I mean, you could do it at the end of November. I haven't seen that letter and I can't review it now, so I can't recommend to you whether or not you should send that letter or not. Or like, speak to the law in the letter or anything like that, but that does make logical sense.
Okay.
To send it at the end of November, yeah.
So do we have protection under the COVID? I'm sorry, I'm just so lost right now. I just don't, I'm sorry.
This is what I was talking about. So the state law expired. So you're not protected under the state law. The state law did say you couldn't evict people for substantial remodel, but that expired at the end of September. The county law would also prevent, the COVID law would also prevent this kind of eviction, but it's kind of unclear whether or not it still applies.
Oh, okay. Okay.
But that's what I'm saying. You would still fight it. You would still make those, a lawyer would still make those arguments.
Yeah. Okay.
Okay.
Thank you.
No problem. April.
Okay, sorry. I guess my only question is what protections are still available to tenants that fall into the county areas, and this would being a single family home and that's been rented, and a 60-day notice that owner wants to move in. Is there any protections at all, like for people that are faced with this dilemma?
Okay, so it's a single family home that may or may not be protected by the Tenant Protection Act, right? Is that what we have been talking about earlier?
Yes.
Let's assume, I mean, either way, what your question is about the COVID protections, right?
Well, COVID protections, any protections that are available. I mean, I know you said that the county law and state law, and since this is in unincorporated county, because it's in La Puente.
Yeah, so it's the exact same thing I was just saying. Yeah, to Laura. So it's an owner move-in, so that's a no fault just cause. So even if it's protected by the Tenant Protection Act, that is an allowable kind of eviction under the Tenant Protection Act.
I need to interrupt. La Puente is a city. It's not unincorporated.
Well, actually, the address, they say it's La Puente, but when I looked on the map, it's actually part of Valinda, which is the unincorporated section. Okay. So I don't know if it would fall under La Puente or under Valinda, because I'm not great with maps. I'm a girl.
No. Okay, so it doesn't matter either way, because the question is whether it's its own city or in unincorporated LA County, right? So we're still talking about the county ordinance at this point. So this is what I was saying before. The county, so we know that they have provided some just cause even under the Tenant Protection Act. Right. So now the question is, does the COVID protection apply to keep this kind of eviction from moving forward?
Right, and all rent has been paid up in full through the whole COVID.
So no, we're just talking specifically about owner move-in. So the LA County does say that you can't have a no fault eviction, which includes owner move-in, through January 31st, 2022. However, many judges have been thinking that those LA County protections are totally preempted. They no longer are valid because of the state law. So I can't give you 100% answer on it because it'll depend.
Okay. But so the LA County ordinance, that would be 3088, I think.
No, that's the state law.
Oh, that's the state law. So it's 1482.
No, that's AB 1482
That's the TPA.
is the Tenant Protection Act. Thank you. I was like, I know that one, but yeah, because that was, so it helps, this is a good general lesson. It helps to refer to the statute, right? So, if you're talking about the Tenant Protection Act, use 1946.2. Yeah, just because though, so when we say AB, though, that is a bill, assembly.
Right.
Bill.
That's it. Yeah. Well, that's how I pulled it up, was by the AB 1482 when I was reviewing it.
For sure. That's, and which is fine. But if you were ever, citing it like in a letter to your landlord or something, make sure you are using the statute, because that's what's actually been passed, right? Like,
okay.
Yeah, the bill is the bill, before it changed
just like
the
they
law.
said in Schoolhouse Rock. I'm just
exactly,
yes.
Exactly like that. Okay, did that answer your question?
Yeah. So,
okay.
Yeah, I'll get back in touch with Ira here and see if he can help me with perhaps, concocting some kind of an answer.
Okay. Jasmine?
Yeah, just in regards to the AB 1482, that's the Tenant Protection Act, right?
AB 1482 is the Tenant Protection Act,
Okay.
but this is what we were just talking about. So that is an assembly bill. That's the bill that they passed to create the Tenant Protection Act. And then once they pass a bill, they change the law, right? The actual statute. So the actual statute for the Tenant Protection Act, what you would refer to if you were citing it to the judge or something, is 1946.2.
Got it. Okay. Now, in regards to the rental increase that is allowed, if a tenant got an increase in May of 2020 in the middle of a pandemic of more than 10%, and then is getting another increase this year for December 2021 for another increase of more than 10%.
Gosh.
And I just became aware of this AB 1482.
Okay, so what kind of unit do you live in?
It is a 6-unit apartment in the city of Monterey Park.
How old is it?
It was built in 1960.
Okay, so it does sound like it's protected by the Tenant Protection Act. So the Tenant Protection Act, I couldn't tell you what the allowable rent. So it's basically the allowable rent increase is calculated by like the cost of living increase each year.
Yeah.
So unlike in the city of LA in rent stabilized properties where there was a rent freeze, they couldn't increase the rent. Landlords weren't allowed to increase the rent at all in LARSO units in the city of LA for 2020 and 2021. So starting June 2020, there wasn't a rent freeze under the Tenant Protection Act, but 10% is in excess of what's an allowable rent increase. And it should be a violation of the price gouging law that Ira and I were just talking about, because you can't, basically it's not a law that specifically has to do with rent. It's a law that says when there's a state of emergency, if you increase your prices for anything, including the property that you're renting out, by more than 10%, it is price gouging, which is illegal. So it sounds like it's both a violation of the Tenant Protection Act and is price gouging.
Okay.
Let me add something about the anti-gouging law. It's a crime to violate that law. It's a criminal law. And I was looking into this recently. Everybody, if you want to, you can complain to your city attorney and essentially ask them to prosecute the landlord for a crime, a misdemeanor, for violating the Tenant Protection Act. Sometimes that's not a good idea if you want to stay in good terms with the landlord, but sometimes that's not a possibility anyway. If you live in the city of Los Angeles.
So Monterey Park is considered city of Los Angeles?
No, it's a separate city.
Okay.
If you live in the city of Los Angeles, folks, you can just go to the website of the city attorney of Los Angeles, And they have a place where you can make a complaint for asking for a criminal prosecution. And if you live in the county, you go to the website of the the district attorney of LA County. And if you live in a separate city like Monterey Park, you go to the website of your city, the city of Monterey Park, and they will have some kind of city attorney. They will have a city attorney.
Okay. Now, so in regards to that, so how would I know if I'm under like rent stability size? I'm sorry, I'm not saying it right.
No, it's okay. Rent stabilization. So, we just talked about this. So it sounds like your unit is protected by the Tenant Protection Act, which is a type of rent stabilization. Oftentimes when people talk about rent stabilization, they're talking about LARSO, which is the LA rent stabilization ordinance that's in the city of LA, or they're talking about the LA County rent stabilization ordinance. But the Tenant Protection Act is also a rent stabilization ordinance. It limits the amount of rent that can be raised each year. If you're in a 4-unit property that's more than 15 years old, it sounds like you are protected by the Tenant Protection Act.
Okay. Now, since it was raised by more than 10% and I've been paying more than 10% last year and now she wants it going forward next year, can I go back and adjust the rent? Meaning, so like, say for instance, last year
I understand your question, Jasmine. So, okay, so what I would recommend doing is, since it sounds like it's an invalid rent increase, you can keep paying the same amount of rent, notify your landlord that's an invalid rent increase in violation of the Tenant Protection Act and the anti-gouging law, and keep paying rent as it is. If they try to bring an eviction case against you for that, keep all proof of everything, keep proof of every payment, keep proof of all communication, and get legal help immediately after if they try to file a case against you for that. And you should be able to defend yourself by saying it was an illegal rent increase.
Let me add
sorry, go ahead, Ira.
Yeah, you're by not paying the increase, even though it's an illegal increase, you are taking a chance of getting evicted. If you can afford to pay the increase, you might be able to. Well, let's see. We're near the end of the month. If rent is due on the 1st of the month, which they usually are, it'd be wise to try and negotiate or inform the landlord this increase is illegal, and explain why, and if you can do it in a cooperative way with the landlord, great. And they might back down, or you might be able to get a lawyer to help you do that. I'd help do that. I don't charge. It's better to get them to back down. As Cherry says, if you just don't pay the increase, you would probably win, very likely win, if they tried to evict you. There's no guarantee that a judge would follow the law, and or that something untoward, unexpected would happen in the eviction case.
Okay. Okay, yeah, Ira, I would definitely reach out to you. Thank you so much.
All right.
Thank you, Ira. Okay, we'll keep going. I will say we're going to close out this workshop at 7 today. So if you do have any questions, make sure to raise your hand under reactions. Luis, and make sure to keep your questions general. Luis?
Hi, I look into the information that you asked. Yes, the building was built around 1986. And then I look a little bit more down in the website that you guys can provide. And I saw these things, the 1482, no, the RSO, no.
Luis, it would be better if you get your question.
Okay, so in that case, if the building is from 1986 and all those protections act do not apply, what are the options?
Okay, Luis, I think that it's confusing why it said that AB 1482, which is the Tenant Protection Act, doesn't apply. I think we need to look specifically into what's going on with your building because it's older than 15, it's more than 15 years old, and it sounds like it's a ton of units. So they could be condos, but it really is specific to your unit. It's not a general question. So my recommendation to you is still the same. I think you should get in touch with ACE, get in touch with an organizer since they're trying to evict your whole building. And you could go to Elena's office hours so that you can specifically talk about your building and we can research your building and get into the details that way.
Okay, thank you very much.
No problem. Do you have the link for Elena's office hours?
I think so. I think I got Vicente Ceja's number there, but I didn't
Okay,
look.
good.
Can you send the link that you were talking?
Exactly. I'll do that again.
Thank you.
Sorry. I think Sam had a question.
Yes, I have a short question about the future rent. Is that for 3 or 4 months? I keep hearing different months that we could ask for.
So if you're applying for prospective rent, right now the rental assistance will only do October, November, and December. Well, it's not prospective anymore with October, but November and December of this year.
But how about, because on the application, it has January 2022 till December, and it's all dark. And a phone rep said that it might open up, and then I have to put in another application.
Yeah, Sam, this is one thing I cannot answer. I will not be able to predict if Housing is Key is going to open the January 2022 and more for rent that's there months that are covered by the rental assistance. But as of right now, it ends like the last month you can ask for is December of this year.
Oh, okay. Wonder if I had paid for October, but I put it on my application because I was told by the consumer business affairs that I had to pay. So I just paid so they wouldn't evict me.
So I don't know the specific details of how you would do this with the Housing is Key application. You know, I don't work for them. I don't know the details of the application, but you should call them and notify them that you don't owe October 2021 anymore.
Okay, thank you.
So that your landlord isn't like getting double payment and then you're risking fraud because, you know, you've asked for that money for your landlord.
Yes, and I already paid for it.
Right, exactly. So just call them.
I thought that they could just convert it to January, move it forward.
No.
Oh, okay.
Not as of right now.
Okay, thank you.
No problem. Sarah?
Yeah, hi. I posted on the chat room my question. I don't know if you want to read it. It's regarding the proof from the California COVID-19 program. Should a tenant send it to the landlord regardless of the fact that if he filed for eviction or not? Like you you can log into your account and generate that proof and print it. Yeah.
Okay, so this tenant got a notice from Housing is Key saying, you know, you can pull up this proof that you're participating in the program to send it to your landlord. I would say send it to your landlord. Let them know that you've applied for the rental assistance so that you don't have to worry about, or at least you can lower the risk of them filing a case and then, you know, risking a default and stuff. So I don't see any reason why you shouldn't send it to your landlord.
Even though they're stating if he filed for eviction, as if, you know, we need to send it after.
No. This form can be used in response to an eviction action. If your landlord is unaware that you've applied for the rental assistance.
No, he's aware.
Okay. I mean, I still don't see the harm in sending it preemptively, but you can wait until after an eviction has been filed.
Okay, thank you.
No problem. Okay. Anyone else?
How do you do it?
Teresa, we can hear you. Do you have a question?
Yeah, I do. Well, I got in late, but my thing is with my owner is that we talked last month.
Teresa, I know you got in late, so I'm going to repeat this for you. I don't want you to talk about the specifics of your case at all. I don't want to hear about what your owner said or anything. This is only if you have general questions. If you have specific questions, I just posted the link for Elena's office hours. That's where you want to go to be able to talk about your specific case. But there's 23 people in here, so you don't want to talk about the specifics of your case.
Oh, okay.
If you need to talk about the specifics of your case, and that's the only way, you're going to get a helpful answer, I would say you should just go to Elena's office hours. I can repost it just because I think it's lost a little bit.
Okay. But with a 3-day notice, do you really have to leave within them 3 days?
No. So just because you get a notice to quit, it doesn't mean you have to leave. If you don't leave after the 3 days, your landlord then has to file a court case against you. They can't just change the locks on you. And then if you get any court paperwork, it'll be called a summons and a complaint or a notice of unlawful detainer. If you get any court paperwork, you should go to stayhousela.org and click on Get Legal Help so that you can get assistance with the court case if you qualify.
Okay.
But just because you get a notice to quit, it doesn't mean you have to leave. Only a judge can make you leave. So once the landlord goes through the whole court process, if they were to win, then they get what's called a writ of execution. They can take that to the sheriff, and then the sheriff posts a notice to vacate on your door. And then 5 days after that, then the sheriff comes and changes the locks. That's the only legal way to do it.
So if he tries to come and change the locks, then
if you're worried about him coming to try and change the locks, what you should do is make sure no matter where you go, keep some proof that you live there, like a lease, utility bills in your name, any kind of official paperwork you've gotten to that address, anything that shows, this is me, here's my ID card, here's the address, so that if they were to change the locks, when you call the police, you will be able to show the police that you're a tenant there.
Okay. Well, what about if he sends like a harassing text telling you, I need you out immediately? So how would that work?
That doesn't matter.
Okay.
It doesn't matter. Your landlord can't just say, I need you out immediately, and then you have to leave. So yeah, what I'm saying about the court process is true. They have to go through that court process.
Okay. That's what I was wondering.
Okay. Great.
Because it was kind of stressful, to wake up and, Lord had already talked about something, but then it turns out that he just reneged on everything, and you're like, well, what's going on? Not a 3-day notice.
I know. I understand, Teresa. Hopefully that was helpful. Does anyone else have a question? Okay. I don't think I missed any in the chat. So, okay, everyone. Ira or Vicente, do you have anything to add, or should we close out?
I think we're good to close out. We have, and thank you, Sarah, for putting that on the chat. If you do have any other specific questions or lingering questions that you couldn't get answered, your best bet would be to also go to Elena's office hours, so just bumping that up in the chat. Aside from that, I think we're good to go. I don't know if Ira, if you have anything else to say, or if not, you can go ahead and close it off for tonight.
Okay. Great. Okay, thanks everyone.
Night.
Thank you, everyone.
Bye, good night.
For the rest of your night. Thank you, Sharon.